Resuming debate, reprise du débat, the Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. As I rise for my first full speech in our new chamber, I want to begin by acknowledging we're on the traditional territory of the Algonquin people, expressing our gratitude for their patience and hospitality. Miigwech. Mr. Speaker, there could not be a topic that's more fraught emotionally than child custody disputes in marital breakdowns. And it certainly isn't new. As I pondered, having been in the deep weeds of this bill through clause by clause with my many amendments, to step back at report stage and really think about our topic, it struck me how very long humanity has struggled with the difficulties, as my honourable colleague mentioned earlier, that from St. Albert, that judges have a hard time with these decisions. It put me in mind of the first book of Kings, the wisdom of Solomon, and that it was 2,500 years ago that the quite well-known story of two women coming to King Solomon with the claim that a baby was theirs. It was a child custody dispute 2,500 years ago, and in trying to discern who was the real mother, we all know the story, King Solomon said, "Bring me a sword. I'll cut the child in half, and I'll give half to each one of these women." And of course, the real mother said, "Don't. Give the child to the other woman." So, of course, that's when King Solomon said, "Well, now I know who the real mother is," and that's that. Our courts still struggle, and when they get it wrong, sometimes children die. It's still the case in this day and age, and perhaps increasingly so, as violence against an intimate partner sometimes turns into revenge against that intimate partner. I wanted to start because I raised these two cases when this bill came forward for first reading, and I raised them to our then Minister of Justice to ask, will this bill help in these cases? I now believe it will, or more accurately, it might. So the two cases I want to raise with you are two women from Vancouver Island, where I live, both of whom lost their children because a judge wouldn't listen to them in a dispute over custody. One is a case that's been raised in this House many times. Back in 2015, Alison Azer's children were taken on a vacation over her objections. The judge ruled that her former spouse, who was a very well-respected doctor, in fact, he even was in the kind of echelons where he was at least an acquaintance of our former Prime Minister. So he was respected in the community, and the court took his word that in taking Alison's children on holiday, he would bring them back. Alison Azer begged the judge not to give the passports of her children to her former spouse, who was originally from Iraq. She was terrified the children might be kept there, and that's in fact what's happened. The children, Canadian citizens, still live overseas. Sharan, Rajivan, Dirsim, and Metan have now been so culturally and, well, just egregiously alienated from their own mother that when she finally got a chance to see them, they were not willing to run to her arms. It's one of those things that just breaks your heart. But the judge didn't listen to Alison. The next case is, if anything, worse. It is worse. And January 2018, over 1,000 people crammed into Christ Church Cathedral in Victoria for the funeral of Chloe and Aubrey Berry, who were murdered by their father on Christmas. And I was one of those mourners. I've never been through anything as difficult. The clergy struggled to find meaning, to give people hope, because those little angels were adored by their classmates, their family. Of course they were. They were beautiful little girls, and murdered by their father. Now, their mother also sought to convince a judge that there should not be unsupervised visits for her children with their father. And tragically, not just unfortunately, tragically, the judge didn't see evidence that there was existing evidence of threat or harm that was sufficient to deny the father an unsupervised visit. That mother's name is Sarah Cotton. And when I talked to Sarah afterwards at the reception with the mourners, she was startling in her clarity. She was articulate and asked me to help work to make sure that what happened to her wouldn't happen to other mothers, that the family court system had to change, that judges had to be prepared to listen, and that they shouldn't be so concerned with their rights of access to a father that they should ignore the cries of a mother, that there was reason to be concerned. So, the rest of what I'm going to say about Bill C-78 is dedicated to Allison and Sarah, extraordinary mothers who've lost their children because they couldn't convince a judge to listen to them about the threat of allowing those children to go with their father, either overseas or for a Christmas visit that ended in the children's murder. Now, where I find hope in this bill is in the recognition of family violence and the way in which the definition section of the bill allows for a lot of consideration by a judge of a definition that falls short of they've already been hurt, he's made specific threats. And I should step back and say, in some contexts, it's not a mother and a father. It could be a mother that's a threat, and we're also dealing in situations which are not cisgendered individuals in all cases who are always in hetero relationships. We recognize that gender violence and gender inequity, it transcends hetero norms. But let me just continue with the normal way in which, not normal, with the traditional way in which we talk about family violence, which is generally the case in interspousal violence, tends to be a father making threats and a mother who's in the weaker situation, either economically or in terms of the power imbalance, as has been referred to by other members. In this definition of family violence, which is, I think, what makes it helpful, it's not it's not an exclusive list. It uses examples, but it's not a closed list. So it defines family violence as any conduct, whether or not the conduct constitutes a criminal offense, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for that of another person, and in the case of a child, the direct or indirect exposure to such conduct, and includes, and then we have a non-exclusive list of A till I. I found it impressive, really, in terms of recognizing psychological abuse, and also recognizing that it's a real warning sign of, under subsection H, threats to kill or harm an animal. You know, a threat against a family pet. If a judge hears that now, the judge should say, okay, that falls within this definition of family violence, and we ought to take action to protect these children. We need to think of all these elements. It's not going to be perfect because judges will continue to make mistakes. But I hope that the recognition in this first reform in more than 20 years of our family law will direct the mind of judges to these various elements of family violence, to psychological stress. And there's no question that there are times, and we know them in family law in Canada in recent times. I certainly used to practice a little bit of family law. I found it very difficult because it's so emotional. But we certainly know that there were some times that because it became so confrontational, that there would be false charges against one partner or the other in an effort to gain custody. So, but the larger risk is if you don't listen to the parent who's really concerned that the child might be at risk, if the parenting time, as we now describe it, is allocated to a parent who may be capable of kidnapping their own children and alienating one parent from their children, doing huge psychological damage to the children, or in the worst case, as I've mentioned, capable of murder. So that I think is an improvement. The injection of a more sophisticated understanding of family violence, the context of it, and defining it is certainly an improvement. I also, of course, this law is primarily child-centered legislation. It's much closer to what we've had in British Columbia for some years, which is under the British Columbia family law, a focus on the best interests of the child. So it's again interesting that the two cases I've raised took place in BC, even though they had this kind of framework of focus on the best interests of children. It suggests that the changes are going to be cultural, are going to be training. But I hope that this legislation is going to protect children. Its goal is certainly to always have paramount the best interests of the child, and it's for that reason that I support this legislation. It does have some other substantial improvements that are more about logistics, but one of them I just referenced all too briefly. When we use language about custody and access, we created it, perhaps inadvertently, well, I think inadvertently, more of a contested, gladiatorial struggle to win custody, to be acknowledged as essentially the better parent. It created, in an emotional context, marriage breakdowns are certainly about the most emotional time in a person's life, and the children were often treated as the spoils of war, and the word custody tended to fuel that. At least that's what the drafters of this legislation must have considered in changing the language, and a lot of family law experts who testified to the committee said that they hope this would take away some of that notion of winners and losers, of winning custody, because we now talk about parenting time, and parenting time is described in ways that suggest that it's shared. Parenting time requires responsible behavior during that parenting time. I think it's progress. I think it will help take out some of the conflict. I certainly hope so. As I said earlier, at least it might. Another big improvement in this legislation, and long overdue, is that it allows a judge to access income information about one or the other parent from other government sources. We certainly know that it has delayed these cases. It has cost the court time. It has already stressed out parents, and particularly where one spouse has more income than the other, which is often the case, where they're resistant to disclose voluntarily. Now the judge has an access to get other information from other government sources. This will help for sure, and is a win-win-win in a couple of different directions. It's already been discussed at some length that the improvements around a legislated test for the question of one parent moving to another location with a child, and how that affects the other parent and access to parenting time. The rules here will, by being legislated, create a lot more certainty than in the past, where we were dealing essentially with the Supreme Court case of the 1996 case of Gurdon and Gertz. This effort to legislate the test for mobility is clearly progress. And another thing that I think is worth reinforcing here is that in cases where family violence isn't at play, opportunities to go to mediation, certainly an improvement. Anything that takes the adversarial nature of family breakdown turns down that temperature and makes it all about what's in the best interest of the child. And there's no doubt, and I was trained as a lawyer, I've mentioned that before, it's an adversarial thing. We're taught to go into courtrooms and win. That's not helpful. If in a family breakdown situation you can avoid lawyers and avoid courts and work through mediation, everyone will be better off, except the lawyers. Well, that's okay. Well, I'd so hope that the kind of cooperative law that we've seen that's developing across Canada, the access to mediation, which is stressed in this bill, will help families get through this crisis period in their lives with their relationships intact. It certainly is the most helpful thing for the children. Now, I did mention I brought forward a number of amendments. My amendments weren't accepted. I wanted to see an amendment that dealt with this issue of maximum access. There was a Liberal amendment that was quite similar. I hope that we'll see that playing out in a way that addresses some of the concerns that were raised by legal experts. I also have put forward amendments to have more of a focus on the question of the judge turning his or her mind to the specific issues when a child is Indigenous. We've seen far too many Indigenous children in this country taken from their families historically and currently, and we need to pay attention to that, and wherever possible ensure that a child is in a community, is in their culture, has access to their language, access to other relatives. The Indigenous nature of child custody is referenced in the bill, but not as completely as it would have been had my amendments been accepted. As I've said, though, Mr. Speaker, this bill is a substantial reform of family law in Canada. It's long overdue. I so hope it works. And I hope it works to avoid ever again the tragedies that I've mentioned already. There can be nothing worse for any parent than to lose their children. And losing them in divorce is tough. Losing them forever is unbearable. And I hope and pray that this legislation will be followed up with additional funding, more training, perhaps mandatory training for judges to think through these cases, read and think about Aubrey, read and think about Chloe, about Allison's children, and whether when they're dealing with the case in front of them, they think, what's the worst thing that can happen if I get this wrong? Because that's ultimately the burden that judges carry. And I wouldn't want to be the judges who said, I don't worry about the Azer children going overseas. I don't worry about the Barry girls going to their father at Christmas. We need to, all of us, make the best interest of the child the guiding light of all family law. And indeed, I couldn't agree more with my honourable colleague from Saint-Hyacinthe-Bigot. It would have been better had this legislation included an acknowledgement of our obligations under the United Nations Convention on the Rights of the Child. But there's much more that can still be done by establishing, as we have worked for years in this country, particularly retired Senator Landon Pearson led the charge to have a child advocate at the federal level to look at all the broad range of issues as they affect our children. And with that, Mr. Speaker, I thank this House for the opportunity to speak to Bill C-78. I look forward to voting for it at report stage and third reading and seeing it go to the Senate, where potentially they may go back to some of the amendments that failed in the House. Thank you.
Questions and comments. Questions et commentaires. The honourable member for Mount Royal.
Thank you, Mr. Speaker, and I want to thank my honourable colleague from Saanich Gulf Islands. Her contributions at committee with the amendments she proposed, always well-reasoned, were much appreciated. And whether we come down on the same side or not on her amendments, I always enjoy discussing them with her. My honourable colleague covered multiple aspects of the bill, but I wanted to ask her one question about an area she did not cover. She was present when the committee unanimously adopted an amendment guaranteeing the right to divorce in either English or French in every province in Canada. As my honourable colleague had mentioned in her speech, only a certain number of divorces actually go to court. Theirs is the most confrontational, the most controversial, and people are incredibly emotional. It's often the only time that they're actually in contact with the justice system. And it is only right that they be able to do this in their own language. And if she did not have an opportunity to vote on those amendments, I would like to know how she would have voted.
Member for Saanich Gulf Islands.
I want to thank the honourable member for Mount Royal for being such a fair chair in circumstances where, as he will know, I've constantly complained of the process that forces me to bring amendments to committee at clause by clause rather than bring them forward at report stage here, which was the right I would otherwise have had. But that's the reason, if anyone's wondering, why I couldn't vote. I don't have rights at the committee to vote on my amendments. I can speak to them, and if I had had a vote, it would have remained unanimous.
Questions and comments. Questions et commentaires. The honourable member for St. Albert, Edmonton.
I thank the member for Saanich Gulf Islands for her comments and certainly acknowledge the horrific cases involving Aubrey and Chloe Berry on Christmas Day of last year, and of what has happened to the Azer children. Allison comes from St. Albert, and her older children went to school in St. Albert while they were there. And I've met teachers who taught her kids. And I've had the opportunity to meet with Allison many times as she came here to fight for the return of her children. And her incredible determination is inspiring in the face of such adversity, and it's so tragic that unfortunately she hasn't been reunited with her children. But I do want to ask the member about the issue of changing some of the language in terms of custody and access. On balance, I think it is a positive, but there was some concern raised from some witnesses about the impact that might have on matters in which there's an international component. For example, a father who abducted his children in Pakistan. It was said that the court in Pakistan was very insistent, or it was very helpful to have that term custody, that the mother had custody. So I was wondering if the member might speak to that. And also just the fact that in terms of some child support and immigration domestic legislation, that custody and access are the terms that are used.
The honourable member for Saanich Gulf Islands.
Thank you to my honourable colleague from St. Albert, Edmonton. And I hadn't realized the connection that he had directly with Allison Azer and the children in St. Albert. I've always thought of them as children from Vancouver Island, but it remains heartbreaking, especially when you were close to it. Allison's an amazing woman. Look, I think that we are making progress by calling it parenting time. Other courts and other jurisdictions have problems. I had a horrific case of a child who was kidnapped by a non-custodial parent and taken to New Hampshire, where the New Hampshire courts looked at a custody order from the province of British Columbia as if it had come out of a Crack-a-Jack box. They didn't give a fig what the courts in British Columbia had said. They said that this non-custodial father who had broken the orders of the province of British Columbia had no bearing for them. Now, there are international conventions, I got deeply involved with them, about the return of children when you go into this kind of situation. It's very difficult, and I don't think the wording, my point is, I don't think the wording will be definitive. It's a matter of the Canadian government getting behind the treaty, working to get children who've been kidnapped by a non-custodial parent, getting the reciprocal government to recognize that right under the treaty. And I think the clarity that our Minister of Justice or the Prime Minister could use in a situation like that to say, in the context of our Divorce Act, parenting time conveys rights that that other parent didn't have. So I think we'll work through it just fine. I think the benefits for not using the word custody and access in our family law legislation federally far outweigh the risks of another jurisdiction not understanding our law. Because if you can't get the United States of America to understand that British Columbia's Supreme Court is actually a responsible court with jurisdiction, knowledge, and clout, and language that was at that time the same, I think we're going to have problems whenever we have transboundary issues with children.
Questions et commentaires, questions and comments, honorable député de Saint-Hyacinthe-Bagotte.
Merci, Monsieur le Président. Je remercie ma collègue. Et bien que ça n'a eu qu'une valeur que symbolique, j'ai été heureuse de voter en faveur de la plupart de ces amendements. J'aimerais lire une courte citation de Pamela Cross qui est venue témoigner devant notre comité. Elle nous a dit, en outre, nous recommandons, parce qu'elle parlait au nom de l'association qu'elle représente, mais aussi d'une large coalition de groupes de femmes, nous recommandons l'ajout d'une définition de violence contre les femmes, une définition qui reconnaît qu'il s'agit d'une forme de discrimination fondée sur le genre, dont sont victimes les femmes de diverses façons, et qui est façonnée par d'autres formes de discrimination et de désavantage. Il y a ici un recoupement avec la race, l'identité autochtone, l'ethnie, la religion, l'identité de genre ou l'expression de genre, l'orientation sexuelle, la citoyenneté, le statut d'immigrant ou de réfugié, l'emplacement géographique, la condition sociale, l'âge et le handicap. J'aimerais avoir l'avis de ma collègue sur le fait que cet amendement a été rejeté d'ajouter une définition plus précise de la violence contre les femmes. Est-ce que selon elle, ça viendrait accroître la portée de cette loi que nous l'incluions?
L'honorable député de Saanich Gulf Islands.
Merci, Monsieur le Président, et merci à ma collègue. Oui, je suis tout à fait d'accord avec ma collègue parce que c'était le témoignage profond. Quand même, je pense que le projet de loi de 78, c'est une grande amélioration pour le système de loi sur les questions des familles, les droits des femmes. C'est toujours, on doit améliorer, renforcer les droits des femmes. Mais je pense que la définition ici de la violence de la famille, violence familiale, pardonnez-moi, c'est une avance aussi pour les droits des femmes.
Questions and comments. Questions et commentaires. A very brief question, the honourable member for Winnipeg North.
Thank you, Mr. Speaker. I'm wondering if my colleague could just provide her thoughts and comments in regards to the issue when you think of custody-related issues during a family breakup. The costs are becoming fairly prohibitive for family members, and really the biggest disadvantage that is to the children when they have to pay so much in terms of courts. And if she could maybe just share with us her thoughts on that issue. I know from a personal perspective that it would be nice, and this is one of the reasons why it's good to see this legislation, is it at least starts to begin to deal with the issue in a much broader sense, but brings more attention to the issue at hand in itself.
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and thanks to my friend from Winnipeg North. No, when we're looking at the economic impacts of family breakdown, and especially in light of the last conversation about the impacts on women, it's very much the case empirically that women suffer more economically in family breakdown, and that most of the single-parent households in Canada are single-parent households where the woman is raising the children and responsible for economic support and has all these additional burdens. If you add that up to the ruins and the spoils of war approach to a divorce, the legal bills, the court bills, I mean, the bills that you have in having your own lawyer, sometimes your own accountant, these costs are large. Time to find, to go into a court, when you get into actually having to make court appearances, you've also got childcare costs. All these costs mount up. So one of the advantages I know that this bill attempts to achieve is more efficiency, speedier handling, wherever possible, moving to mediation, as well as, of course, the fact that a judge can give an order to force a resistant parent to provide the information about their financial situation. All of this should reduce the overall burden of costs in family breakdown.